Today, we continue with the issue of tribal law, federal Indian law, and immigration. As I was saying in another presentation, we have, according to the Constitution, the United States Constitution, we have a limited government. In other words, our Congress is not like the British Parliament that can make or unmake any law. We have a limited government. That's the whole idea of a republican form of government. Now, Article 1, Section 8, from Clause 1 to Clause 18, gives so much, or I should say, so many powers, that many powers to Congress only. It doesn't give it absolute power to make any law it likes, and God knows we have hundreds of thousands of statutes in our statute books. In fact, in 1996, they even had to make a law to define marriage, the Defense of Marriage Act, between a man and a woman. Now, as time marches on, I'm sure they'll make a law that a human being must marry another human being, and you can't marry an animal. If you get my drift. If you got to make a law explaining basic things in life, something is seriously wrong in a constitutional legal matrix when you have to explain everything. Oh, breathe only oxygen, you're not supposed to breathe anything else. They'll make a law about that even. So coming back to immigration, can Congress make any law it wishes to make? It cannot. Under the convention of a limited government, it can make that many laws, and that's it. We have the so-called doctrine of the separation of powers. That's a fallacy. It's a myth. I mean, our judges, they're basically politicians in robes. A federal judge is somebody who knew the governor, and the governor recommends the federal judge to the president. Now he becomes a federal judge. Now, if the president is Democratic, chances are the governor who introduced this lawyer to the president or recommended this lawyer to the president may be a Democrat, or if he's a Republican governor, he will find a lawyer who's a Republican and recommend him to the president, who will make a Republican appointment, of course. So now this judge wears his robes and is either Republican or he is a Democrat. So we have political affiliations which disturb the balance. So now, immigration into the United States vis-a-vis federal tribal law and tribal law. Ab initio, right from the beginning, we must understand that all these people who came into America never sought the permission of the Native Americans, the indigenous aboriginal people. There is an argument that, well, we didn't have passports at that time, we didn't have... Come on. Are you trying to tell me that there wasn't a passenger manifest? You mean to tell me nobody on shore knew who was on that vessel, if that vessel sank, for example? So all these arguments justifying why they came here is like rearranging the deck chairs of the Titanic. All right? They made a mistake. They made a huge blunder of a mistake. And how do they cover up their tracks? They make more laws and more laws and more laws. But Article 1, Section 8, Clause 4 is very clear. In the Constitution, it says, you make a rule for naturalization. You can make a law. So, in my opinion, immigration laws are unlawful. They are illegal. They are illegitimate. They have no traction in federal Indian law or tribal law. They never sought our permission. Now, under international law, when you come and take possession of someone's territory, you're supposed to follow the custom of that territory. That's international law. This is something that was written by Franciscus de Victoria. This is something that's been written by Emeric de Vattel, Hugo Grotius, Professor Ortolan, Professor Phillimore. I mean, these are all learned people who have written books and essays and articles and treatises, and that's available on our website, scripturallaw.org. So we have a limited government. No permission was sought. They came here, they unfurled the flag, they did whatever they did. They assumed this was terra nullius, meaning no man's land, so we can just come and take over, issue land titles, form governments, etc., like what they did in Texas. But that's not so. You need the permission of the tribal people wherever you go and form a settlement, like what happened in the United States or what happened in continental America, Indian country. The second anomaly to this farce, if you like, is the executive orders issued by the president. Excuse me. Where does this executive order come from? It comes from the Constitution. Article 2 in the federal Constitution is that part of the Constitution that talks about the executive branch. And it says the executive power, just like Article 3, the judicial power, and Article 1, the legislative power. So the word power in Article 2 has been used by presidents in the past and presidents that we have today to use a power that is not enumerated in the Constitution. In the matrix of a limited government, you can only have that power which is enumerated. If that power is not enumerated, then it rests with the states or with the people. That's your 9th Amendment and your 10th Amendment. So if the power is not enumerated, mentioned, stated, stipulated, you cannot arrogate that power to yourself. But that's what presidents have done in the past. We've had more than 5,000 executive orders issued since the time of President George Washington. But does it make it right? Just because the president issued an executive order. The president's job, function, job description, and power rests in Article 2, Section 3, which says, he shall take care that the laws be faithfully executed. In other words, it's also known as the take care clause. He doesn't have power to make law. Judge Schwab, Arthur Schwab of Pennsylvania, has agreed to this proposition that the president has no power. Of course, when Judge Schwab made that decision, every Democrat legal scholar, every Democrat newspaper, publication attacked the judge. His job, like the job of every judge, state or federal, is to interpret the law. Judge Schwab interpreted the law. He didn't make a law. He referred to Article 2, Section 3. The president's power is to take care, make sure, ascertain, ensure that the laws be faithfully executed. The president has no power to make law. That's the power of the legislature. The judiciary has no power to make law. Its job is to interpret the law. The president's power is to enforce the law, while the legislative purpose is to make law. So you got a maker, you got an interpreter, and you got an enforcer. That is in our constitutional matrix, and that is the wisdom behind the doctrine of the separation of powers. So when the president says, I am going to overrule the legislature and introduce an executive order to allow 5, 6, 20 million people to live here illegally, that causes a little bit of a problem as far as the supreme law of the land is concerned, and that's what the Constitution is all about. It's the supreme law of the land, Article 6, Section 2. I didn't make that up. It's there. It says, this Constitution, all the laws made pursuant to it, and that shall be made, and all treaties shall be the supreme law of the land. And no state judges, no state law, can overrule that, can go against it. They shall be bound there too, to the contrary notwithstanding. And then you have this Sheriff Arpaio of Arizona, a state. I mean, he's become like a constitutional bulwark against anything and everything he believes is right. The sheriff has no constitutional powers except to enforce the law. He's not there to create law, to make law, or to innovate or invent a law. He's trying to stop illegal aliens from coming into Arizona. Oh, really? Well, he doesn't know history. Sheriff Arpaio, you better read up on some history, my friend, because you don't know history. You don't know legal history. Heck, you're not even a lawyer. So be careful. You can be arrested too, Judge Arpaio, because you are stepping on federal Indian law. You're stepping on the toes of tribal law. You have your jurisdiction. We have our jurisdiction. You mess with us, we mess with you. Your freedom, that is. So please, take time to read the Constitution, all right? And don't take it upon yourself, all right? If you're trying to protect your state, protect your state. But that's a federal issue. And when it comes to Mexicans, it's a federal Indian law tribal issue. Because in our treaty of 1835, the Treaty of Camp Holmes, with the Cherokee, the Comanche, the Washita, the Muskogee, the Yamasee, it's very clear that people who are affiliated, associated with Mexico can come and go. That's Article 3 of the Treaty of Camp Holmes. You should take time, make time, create time, invent time, since you're in the business of inventing rights. Find time, create time, make time, invent time, innovate time, and read the Treaty of Camp Holmes, codified at 7 Statute at Large 474. The Treaty of Camp Holmes, Holmes, Treaty of Camp Holmes of 1835. Article 3 says, people of Mexican ancestry may come and go across there was no border then. So you've artificially created a border between Texas and Mexico. And Texas has always belonged to Mexico. So there are hundreds of books on this subject, where the frontiers people, the frontiers men, the furrier, the hunter, the gatherer, the pelt buyer, the pelt seller, who traded with the Indians, they all came into Texas territory. They kept coming, they kept multiplying, they kept making little villages which became cities, and they started making laws and more laws, and then they petitioned for the United States government for statehood. So that's called the bootstrap doctrine, where you come to someone's land and you create a situation. And you create a situation which favors you and disfavors the other. That's called the bootstrapping doctrine. So that's the story of Texas, and that's also the story of Arizona, New Mexico, and California with the Treaty of Guadalupe Hidalgo and the Gadsden Purchase. None of the natives were consulted. It was between President James Polk, President Fillmore, Santa Anna, where there was a lot of bribery, a lot of gunnery. Either your signature or your brains get on the document. So I made him an offer he couldn't refuse. It's like one of those situations with Santa Anna. We had a standing army staring at the Mexican government. Now let's consider this for a while. What would have happened if the Mexicans and everybody else got together, all the 568 tribes, and took up arms against the United States government? What do you think would have happened? And let's say we had superior weapons too. There would have been a face-off, a standoff, a piss-off maybe, or outright bloodshed. That's what would have happened in the entire matrix of protecting our land. That's what we are trying to do. We are not saying don't come into our land. We don't say we are, well, I think my dog is trying to keep some aliens out, but you're welcome. Ask our permission. That's all we're trying to tell you. Ask our permission. If you can contribute to our economy, you're welcome. But don't ignore us. This is our land under the powers of usucapion. Ownership due to lengthened possession. All right? This is our land. This is Native American land. Any way you cut it, slice it, dice it, and present it, this is our land. We have a constitution of limited government. If you don't want to follow the supreme law of the land, you are breaking the law. In California, there was a young man called Sergio Garcia, who was supposed to be an illegal alien. Now, they tweaked the Business and Professions Code of California to allow an illegal alien to practice law. And now this illegal alien is allowed to practice law in California. Then they didn't want to use the word illegal alien, they said undocumented alien. All right? Sergio Garcia. It's a California Supreme Court case, and it's available if you want to Google it. So the point I'm trying to make here is there is a flaw in the law. At some point in time, I used to call myself a flawyer and not a lawyer. A flawyer is someone who finds a flaw in the law. So now in this case, they twisted and turned and spun that law to accommodate a so-called illegal alien. So if the state government can do that, get involved with federal law, federal Indian law, relating to immigration, the president decided, well, hell, if they can do that, so can I. I'm the president. I'm the commander-in-chief. Okay, do what you have to do, Mr. President, but don't break the law. That's what this is all about. Civilization is about obeying the law. When you break the law with impunity, you are not civilized anymore. You are a scofflaw. You are an outlaw. So, what is the message today? Immigration law is the domain, the property, and the business of Native Americans. The government has recognized our powers of inherent tribal sovereignty and immunity and autonomy. Ask our permission. Not because of an ego trip, but this is our land. respect us. Respect goes two ways. So let's follow the law, abide by the law, comply with the law, and let's not break the law. Because in a civilized society, when you break the law, you're not behaving in a civilized manner. So read the law, understand the law, and let law be the true handmaiden of justice. The United States Supreme Court says equal justice under the law, if that's possible. All law came from the scriptures. The scriptures are the fountainhead of morals and ethics. So law is supposed to be morally and ethically on the same path to mete out justice. Thank you.